And do we have audio? Yes, we do appear to have audio. All right, guys, afternoon, good evening, and good night, and welcome to the verdict on the Ben Roberts-Smith case. I got stuck in the office, so I'm going to quickly whip home. Thankfully, all of this I set up at home and I was able to log in and get it all sorted. But basically, I'm going to be quiet for maybe 5 minutes. Hopefully, YouTube isn't going to yeet me, but yeah. So this theoretically should start playing as soon as they're live. I think they've still got another 5 or so minutes. So, yeah. First time this Florida boy can catch an Aussie live. Well, there you go. But fingers crossed this should be okay. All right. What do I need to do here? Oh, hang on. I can log in on my phone and then switch it across that way.
All stand. The Federal Court of Australia is now in session. Please be seated.
Depending on how long his sentencing remarks go.
In the matters NSD 1485 of 2018, Ben Roberts-Smith and Fairfax Media Publications Proprietary Limited and others, NSD 1486 of 2018, Ben Roberts-Smith and the Age Company Proprietary Limited and others, and NSD 1487 of 2018, Ben Roberts-Smith and the Federal Capital Press of Australia Proprietary Limited and others, for judgment.
Yes, in accordance with the practice of the Federal Court in cases of public interest, the following summary has been prepared to accompany the orders made today.
Stuff it, I'll stay here.
This summary is intended to assist in understanding the outcome of this proceeding and is not a complete statement of the conclusions reached by the court. The only authoritative statement of the court's reasons is that contained in the published reasons for judgment, which will be made available on the internet at the court's website. This summary will also be available there. Mr. Ben Roberts-Smith VC MG has brought 3 actions in this court for defamation. The first action is brought against Fairfax Media Publications Proprietary Limited, Mr. Nick McKenzie, Mr. Chris Masters, and Mr. David Rowe. The second action is brought against the Age Company Proprietary Limited, Mr. Nick McKenzie, Mr. Chris Masters, and Mr. David Rowe. The third action is brought against the Federal Capital Press of Australia Proprietary Limited, Mr. Nick Masters, Mr. Nick McKenzie, Mr. Chris Masters, and Mr. David Rowe. The 3 proceedings have been heard together. There are a total of 16 matters complained of. The publications appeared in newspapers and were made available online. The articles may be divided into 3 groups. The first group of articles were published on the 9th and 8th of June 2018. The applicants claimed that the following imputations were conveyed or communicated by the Group 1 articles. 1, the applicant, while a member of the SASR, murdered an unarmed and defenceless Afghan civilian by kicking him off a cliff and procuring the soldiers under his command to shoot him. Imputation 1. 2, the applicant broke the moral and legal rules of military engagement and is therefore a criminal. Imputation 2. 3, the applicant disgraced his country, Australia, and the Australian Army by his conduct as a member of the SASR in Afghanistan. Imputation 3. The second group of articles were published on the 10th and 9th of June 2018. The applicant claimed that the following imputations were conveyed or communicated by the Group 2 articles. 1, the applicant, while a member of the SASR, committed murder by pressuring a newly deployed and inexperienced SASR soldier to execute an elderly unarmed Afghan in order to blood the rookie, imputation 4. 2, the applicant, while a member of the SASR, committed murder by machine gunning a man with a prosthetic leg, imputation 5. 3, the applicant, while a member of the SASR, murdered an unarmed and defenceless Afghan civilian by kicking him off a cliff and procuring the soldiers under his command to shoot him, imputation 1. 4, the applicant, having committed murder by machine gunning a man in Afghanistan with a prosthetic leg, is so callous and inhumane that he took the prosthetic leg back to Australia and encouraged his soldiers
Special Air Service.
to use it as a novelty beer drinking vessel.
Robert Smith was part of the same thing.
imputation
Special Air
6.
Service. I'm not quite sure why they put the R
The
on
applicant
there.
was not named in the Group 1 articles or the Group 2 articles. A soldier called Leonidas was referred to. By the end of the trial, there was
Leonidas?
no dispute about the identification of the applicant in the Group 1 and Group 2 articles. The third group of articles were published
Thanks,
on the
Matthew.
11th and 10th of August 2018. The applicant was named in these articles and there was never any identification issue. The applicant claimed that the following imputations were conveyed or communicated by the Group 3 articles. 1, the applicant committed an act of domestic violence against a woman in the hotel realm in Canberra, imputation 7. 2, the applicant is a hypocrite who publicly supported Rosie Batty, a domestic violence campaigner, when in private he abused a woman, imputation 8. 3, the applicant, as deputy commander of a 2009 SASR patrol, authorised the execution of an unarmed Afghan by a junior trooper in his patrol, imputation 9. 4, the applicant, during the course of his 2010 deployment to Afghanistan, bashed an unarmed Afghan in the face with his fists and in the stomach with his knee, and in so doing alarmed 2 patrol commanders to the extent that they ordered him to back off, imputation 10. 5, the applicant, as patrol commander in 2012, authorised the assault of an unarmed Afghan who was being held in custody and posed no threat, imputation 11. 6, the applicant engaged in a campaign of bullying against a small and quiet soldier called Trooper M, which included threats of violence, imputation 12. 7, the applicant threatened to report Trooper J to the International Criminal Court for firing at civilians unless he provided an account of a friendly fire incident that was consistent with the applicant's, imputation 13. 8, the applicant assaulted an unarmed Afghan in 2012, imputation 14. The first issue in the proceedings is whether the imputations alleged by the applicant were conveyed or communicated by the articles. There was no dispute between the parties that the Group 1 articles conveyed or communicated imputations 1, 2 and 3. There was no dispute between the parties that the Group 2 articles conveyed or communicated imputation 1. There was a dispute between the parties as to whether the Group 2 articles conveyed or communicated imputations 4, 5 and 6. I find that those imputations were conveyed by the Group 2 articles. There was also a dispute between the parties as to whether the Group 3 articles conveyed or communicated any of imputations 7 to 14 inclusive. Subject to one matter concerning imputation 9, I find that each of those imputations are conveyed or communicated by the Group 3 articles. The one qualification is is that in the case of imputation 9, I find that the imputation which was conveyed or communicated was as follows.
Yeah, Jim.
The
Basically,
applicant is
Australia's
Deputy
current most
Commander of a
decorated soldier
2009
was
SASR
accused of war crimes by
patrol,
a bunch of newspapers.
acquiesced in the execution of an unarmed Afghan by a junior trooper in his patrol. The defences of the respondents in each proceeding are similar. They are justification or substantial truth, Section 25 of the Defamation Act 2005, New South Wales, and contextual truth, Section 26 of the Defamation Act. With respect to the defence of justification or substantial truth, the respondents' particulars of truth are very substantial. They consist of in the order of 150 paragraphs. With respect to the
I've
defence
got to be
of
careful about
contextual truth,
criticising the judge because this
the
guy's in my
respondents
jurisdiction.
in each action plead that imputations 2 and 3, as pleaded by the applicant in relation to the Group 1 articles,
This is my
arise
office.
as contextual
So,
imputations in the case of the Group
this is my
2
view
and
out
Group
my window.
3 articles, and that they are substantially true. If that is so, they have a defence where the defamatory imputations pleaded by the applicant, to the extent that they are not shown to be substantially true,
I was going to send you a
do
link, but I
not
assumed you didn't
further
work.
harm the reputation of the applicant because of the substantial truth of the contextual imputations. In the alternative to these two defences, the respondents plead a number of matters which they contend mitigate damages. The most serious allegations made in the particulars of truth are that the applicant murdered or was complicit in and responsible for the murder of Afghan males who were under control or containment. That allegation is made in relation to 2 Afghan males on a mission to Whiskey 108 on the 12th of April 2009, 1 Afghan male on a mission to Darwin on the 11th of September 2012, 1 Afghan male on a mission to Chinatu on the 12th of October 2012, 1 Afghan male on a mission to Sai Chow on the 20th of October 2012, and 1 Afghan male on a mission to Faisal on the 5th of November 2012. The particulars of truth also contain a serious allegation that the applicant assaulted person 17 on or about the 28th of March 2018 in
That's
a
basically
hotel
what they're
room
claiming,
in
yeah.
Canberra.
Hell of a lot of defamation.
In
if any.
addition, there are allegations against the applicant of assault of Afghan males under detention, bullying of an Australian soldier, and making a threat to another Australian soldier. The trial was interrupted because of the effects of the COVID-19 pandemic and thereafter occupied a substantial period of time. A number of
Thank you, Your Honour. That's gonna
SASR
get
soldiers gave evidence. Their identity was protected, and in the case of their evidence in open court, they were heard but not seen. There were also a number of sensitive documents and sensitive information that necessitated the court sitting in closed sessions. That was done pursuant to orders I made under the National Security, Criminal and Civil Proceedings Act 2004 Commonwealth, and speaking broadly
tens of millions.
related to national security concerns.
I mean, the estimated cost of this trial so far is
I will
$35
publish
million.
what I call open court reasons. They are lengthy. There are also closed court reasons to be provided to a limited number of persons in closed court. I can indicate that the closed court reasons are in the order of 50 pages, and they address in some detail aspects of the closed court evidence relevant to the missions to W108, Darwin and Chinatu. There is a fairly short reference to the mission to Faisal. There are very short references to the alleged bullying of person 1, the alleged unlawful assaults on PUCs, and the intimidation of witnesses, collusion and contamination of witnesses, concealment of relevant evidence and
Feels a
material,
bit that way,
and
Matt.
lies, and the alleged separation of the applicant and Ms. Roberts. I will be asking the parties and the Commonwealth to consider carefully the closed court reasons and advise whether there are aspects of those reasons which may be published on an unrestricted basis as redacted closed court reasons.
He's actually criticising the government for having
It is not practical for me to summarise all of the findings and conclusions as set out in the reasons. The following are the major conclusions.
Oh, okay,
One,
here we go.
the applicant's conduct and actions on the mission to W108 as found means that the respondents have established the substantial truth of imputations 2, 3, 4, 5, 6 and 9.
Shit.
2, the applicant's conduct and actions on the mission to Darwin as found means that the respondents have established the substantial truth of imputations 1, 2 and 3. 3, the applicant's conduct and actions on the mission to Chinatu as found means that the respondents have established the substantial truth of imputations 2 and 3. 4, the respondents have not established the particulars of truth with respect to the mission to Saya Chow on the 20th of October 2012. 5, the respondents have not established the particulars of truth with respect to the mission to Faisal on the 5th of November 2012. 6, with respect to the alleged bullying of person 1, the respondents have established the substantial truth of imputation 12. 7, with respect to the alleged unlawful assaults on PUCs, and this relates to imputations 10, 11 and 14, the respondents have established the substantial truth of those imputations. 8, with respect to the alleged act of domestic violence and imputations 7 and 8, I am not satisfied that person 17's evidence is sufficiently reliable to form the basis of a finding that the assault occurred and that imputations 7 and 8 are substantially true. However, I consider that the respondents have made out the defence of contextual truth with respect to those imputations. 9,
What the
with
hell?
respect to the alleged threat to Trooper J and imputation 13, I am not satisfied that the evidence is sufficiently clear to support a threat of the type advanced by the respondents and that they have shown the imputation to be substantially true. However, I am satisfied that the respondents have made out a defence of contextual truth with respect to that imputation. In light of my conclusions, each proceeding must be dismissed. At this point, I would ordinarily publish my reasons, but I understand that the Commonwealth has an application to make in that regard.
That's correct, Your Honour. Your Honour, the Commonwealth makes an application pursuant to Section 37AF of the Federal Court of Australia Act on the grounds referred to in Section 37AG, subsection 1, B and C, for the Commonwealth to have access to the judgment until 2 o'clock on Monday. This would not restrict access to authorised persons, Your Honour, but would seek that the publication of Your Honour's reasons be delayed until 2 o'clock on Monday or
The Commonwealth's
sometime
making an
earlier.
application that the judgment be
as
held
notified to
until
the
2
court.
o'clock on Monday so they can
Yes,
review
and
it,
that's for the
presumably looking at
purpose
criminal
of?
proceedings.
Ensuring that there's been no inadvertent disclosure of sensitive information, Your Honour.
Yes.
Okay.
All right. And the applicant's attitude?
That is consented to, Your Honour.
Thank you, Mr. Moses.
With respect, Your Honour, we do not consent to that application. Can I very quickly advance the reasons why? As Your Honour, of course, is well aware, there was a very clear delineation between open and closed exhibits, transcript and submissions, both written and oral. Your Honour is, say with respect, of course, acutely sensitive to the need to maintain that separation. Your Honour has written closed court reasons, which, as Your Honour has, may we infer, perhaps being cautious in producing in a way that might in fact overprotect the sensitive information. In light, we would submit of the very clear delineation between what is sensitive and what is not sensitive. We say there is really a negligible risk that Your Honour would have made the inadvertent error of the kind that the Commonwealth is concerned about. And then perhaps more importantly, coupling that negligible risk with the fact that there now exists a necessarily highly truncated summary of what Your Honour has found, we would say it's in the interest of the parties and the public and justice more generally that the full reasoning underpinning those
You
necessarily
just
very
want to be able to
high-level
get out there and
findings be
call them
made
whatever you want
available.
under the sun.
Now, there is a fallback position, if Your Honour were not persuaded of that, which is that with all of the resources of the Commonwealth, 2 p.m. Monday is too long a time. There is no reason we would say why, with a sufficiently large number of people, the judgment couldn't be divided up and a decision be made by, we would say, by this evening.
This evening, you're going to give them 3 hours.
Thank you, Mr. Owens. What do you say about that?
Your Honour, in relation to the last issue, there are not that many people in the Commonwealth who are aware of the sensitive information who would be able to identify if there has been inadvertent disclosure. In terms of public access, with Your Honour's reasons, Your Honour's orders have been articulated. We're just seeking a short period just to ensure that there has been no inadvertent disclosure. We appreciate Your Honour will have taken all steps necessary to try and ensure that hasn't happened. But in these situations where Your Honour and the parties were constantly moving between open and closed courts, there is always a risk of inadvertent disclosure, which once it's released into the public domain can't be undone, Your Honour.
Yes, thank you. Yes, well, Mr. Owens, I'm against you. I do propose to give the Commonwealth the opportunity to carry out that process. So I'll make the orders that have been sought and I'll read these orders in a moment.
Thank you, Your Honour.
Yes,
Your Honour, I have a copy of short minutes of order to them.
yes.
I'm just waiting for this to finish and then I'll run through it, guys, what the charges were, what the counts were in terms of the defamatory conduct and what he was accused of and why this is now really messed up. Just to be clear, guys, this guy was one of Australia's most decorated soldiers. He has the Victoria Cross, our highest medal for courage and duty. Like, this is not going to end well. This is going to turn into a criminal trial.
Now, Ms. Single, there are some open court and closed court reasons for my ruling in relation to 3 witnesses, I think persons 4, 66 and 56, in not requiring them to give evidence under section 128(4) of the Act. It may be convenient for those to be included in the order as well. In other words, you'd be given the open court reasons, then you could do that checking process.
Certainly, Your Honour, we'll do that in the same
Yes.
timeframe.
All right, and I would ask that you complete the task as quickly as you're reasonably able to.
Yes, Your Honour, and
I'm
if the
sure
task
you
is completed beforehand, we'll let Your Honour's associate know.
Yes. All right, well, in relation to that matter, I'll make the following orders.
No, it was judge alone.
Pursuant to section 37AF of the Federal Court of Australia Act 1976 Commonwealth, the Act, and on the grounds referred to in section 37AG 1B and C of the Act, there is to be no disclosure by publication or otherwise of the open court reasons for judgment in Robert Smith v Fairfax Media Publications, Proprietary Limited, number 41, 2023 FCA 555, and Robert Smith v Fairfax Media Publications, Proprietary Limited, number 40, 2022 FCA 1614, defined as open court reasons until either the Commonwealth notifies the court and the parties that it has no objection to publication of the open court reasons, or 2 p.m. on Monday, the 5th of June, 2023, whichever is the earlier. 2, Order 1 does not prevent disclosures of the open court reasons to and between authorised persons within the meaning of the orders made on the 15th of July 2020, as most recently amended on the 19th of May 2022, under sections 19(3)(a) and section 38(b) of the National Security Information Criminal and Civil Proceedings Act 2004 Commonwealth. Now, I think it's a matter of both sets of reasons being handed to
Very much so, and I do agree with you,
the
Matt Payne. Thank you
parties
very
and
much
the
for the super chat.
Commonwealth, and then those orders will now take effect.
Your Honour, there was just one issue that I wanted to raise, if convenient, whether Your Honour would be willing to extend the time within which to bring an appeal from the usual 21 days to 42 days.
Yes. Well, Mr. Moses,
Well, that was always going to happen.
I'll deal with that. And
Please, the Court.
yes. Mara, and the other ones as well. Yeah.
Yeah, basically, so 3 sets of newspapers over the course of about a year, I think, put out a number of news articles. Basically,
All right. Well, I'll make
putting
an
out
order in
allegations that he
each of
committed
the
in war-
three
committed war crimes
proceedings that the proceeding
and
be dismissed.
domestic violence crimes.
Mr. Owens?
This was him bringing a
In
case
relation
against
to
him for
costs, Your
defamation.
Honour, would Your Honour give us 21 days to consider any application for
But
both a
so much
special order
crap
as
has
to
come out
costs
in
in
the
relation
evidence
to
that
the
was given
applicant and any third-party cost order
that
that we
for
may
them
wish
to
to
have
seek?
substantially, for them to have substantiated enough to get away with defamation.
Put it this way,
is-
Your Honour would certainly, we would say, if Your Honour could make pro tem an ordinary cost order in our favour, that would follow inevitably.
sufficient
But
evidence
I think
there
we
that I
indicated
think
in
that
our
they're going to be
written
considering a
submissions.
criminal trial.
We do anticipate making an application for indemnity costs, at least against the applicant, and also a third-party costs order, possibly on an indemnity basis as well.
Yes.
Indemnity.
All right. And then what would happen at the end of the 21
Whoa.
days, Mr. Owens?
We will have filed an application with any supporting evidence. And then I suppose it depends whether Your Honour could program now a response by any affected parties, or the matter could be called for directions.
Yes. Well, the amount of time that the applicants might need to respond, and possibly any third party, might depend
Okay,
on
'cause
precisely
the
what
soldier
orders you
himself
seek.
brought this
So I
against the
think
newspapers.
it would be wise.
This is going to lead
have
to
a
some serious shit, though,
case management hearing,
with
or
everything that's come
directions
out from the
hearing,
government, from the military,
perhaps
and now that we know
28
that
days
there's enough to
after
have
today. Mr. Moses, do
sufficient
you want to be
reason.
heard on that?
There's no opposition to that, Your Honour.
All right. Thank you.
I can see this being investigated.
All right. Well, I'll
Bloody hell. And he whipped through those orders so quickly that I don't know which ones he said that hadn't been proven. But he's effectively dismissed all of the cases. So he's basically turned around and said, no, they had sufficient cause to say whatever they want.
yes,
they-
I'll list the
this, and
directions
this,
hearing for
aside for the like domestic abuse. But that they'd had a
9
contextual
o'clock
defense.
on Thursday, the 29th of June, 2023. Now,
5 were unproven. Thank you.
Mr.
Aside, Andrew.
Owens, you heard Mr. Moses say seeking an extension of time.
I don't oppose it, Your Honour.
Yes. All right.
Actually, from 28 days to 42 days, Your Honour. I think it may have said inadvertently 21 days.
All right.
I should
And
specify that this was on the civil. This was on the civil balance of probabilities. So the
I'll
court has
extend
found that it's more
I'll make
likely
an
that
order
not that it took place, or that they had legitimate cause to believe.
extending the time within which to appeal from 28 days to 42
Yes, I'll go through the
days.
full findings on Monday.
Yes. All right. Well, I will shortly move into closed court to publish my closed court reasons. As I have said, I will ask the parties in the Commonwealth to consider carefully whether there are aspects of the closed court reasons which might be published on an unrestricted basis. And I don't think there's going to be any need to come back into closed court.
Not
The
for our
judge
final.
wants as
Right,
much of it out
we'll
there as he
adjourn
can.
into
We'll stand. This board is now
Okay, so
adjourned.
that's it. Everything else is going to be behind closed doors. So there we go. Holy crap! I'm just going to make sure that none of my work is visible, so that no one can see anything that they shouldn't. I think we're okay. Note to self: don't join the ADF. Note to self: don't commit any acts that can be taken to be war crimes. I mean, holy crap! That's huge. So he's actually. Hang on. All right, let's do this properly. So, because I brought up the charges, thankfully that are at least specified by the financial review, so I can share that and we can quickly run through it. Okay. So what will the judge decide on the Ben Roberts-Smith case? After 110 days in court, 41 witnesses and an estimated 25 million in legal fees, and another 10 or so. No, we had cameras in the court, fam. Closed court is literally because it's matters of national security. They went into chambers to publish the remainder of the reasons. And that is why they're giving them until Monday next week for the government to go through it and make sure that there hasn't been anything of national security that's been inadvertently released. 110 days? Yes. You guys bow to the judge. That's interesting. Yes, we do. We solicitors and barristers on entry and exit of the court will bow towards the judge. Get a toast, call him a war criminal. You're a lawyer. We know you have alcohol in your office. Screw you, but that's not the point. I'm not actually an alcoholic. That is purely for having toasts with clients when we win. Actually, that's actually completely unopened at the moment. I got a new bottle. Judge didn't say several of them were not proven. Yes, but what he said was that there was enough there that there was a contextual truth defense to some of the claims. So although there was some that were substantially beyond the realm, he's basically said, does that mean I've never won a case? No, that's not what it means, Twisted. It means that I've won enough that I keep going through bottles. Fuck's sake, denial. Denial is a river in Egypt. Okay. Federal Court judge will hand down his judgment in the Ben Roberts-Smith against the Age, the Sydney Morning Herald, and the Canberra Times on Thursday in one of the biggest defamation trials ever in Australia. If this had been properly streamed, I would have done this from start to finish. Honestly believe that some numpties have something against Ben. Oh, I'm willing to believe that. Bottle just came out of a paper bag. That's how the client delivered it to me. We drink when we win. Plus unopened bottle, bite me. So the Victoria Cross winner is claiming that a series of articles published by the newspapers wrongfully accused him of war crimes in Afghanistan and domestic violence at home. Basically he said that he's defamation proof. More or less, yeah. He said that based on the evidence that was provided by the Commonwealth Government under the national security issues, evidence of what was provided to the court in closed court, that there's enough there that he believes that the allegations against him were sufficiently true, that they can't be considered to be defamatory. So... Just saying. Do I believe the guy is guilty? I don't know, because so much of it was behind closed doors in closed chambers. The absolute minimum that'll come with this is that they'll strip him his VC. No. He's already said that he'll give it up. It's not that they're going to strip him of it. He said that he's going to willingly, voluntarily hand it over if he was found guilty. If he was found that it was not defamatory. And I should bloody well hope so, honestly, because let's face it, that's going to be so demoralizing for the military. The government brought the opposing complaint in place of the media outlets. No, they were joined as a third party because the government had so much of the material. So, why would he bring defamation if loss could go to war crime? Seems like a giant risk. Look, there's no guarantee that it's going to go to a war crimes tribunal, but in everybody's mind, they're going to think now that there is enough there, because not all of the information is going to be released. Not everything that was put before the court is going to be made known. Is that the soldier guy in the pic? Yes, that's him there. That's Ben Robert Smith there. Hang on, I'll see if I can zoom in a little bit. That's him there. And I have no idea who the idiot standing in the background smiling is. Discovery's a bitch when it's about war crimes? Yeah. Guess he was staying in Bali? Thought Stokes had a claim to the VC if he loses money on trial. It's going to be interesting. He went to the Queen's funeral and Charles's coronation. Yep. He literally was one of our, he was one of the people that we put faith in, and that's why this is so disheartening. And part of me doesn't want to believe it, but part of me sitting here going that I want to see the closed court judgment. I desperately want to see that. Now I'm going to have to wait till Monday. You think you feel bad for him? Mark Donaldson went too. True. Lose the majority of his visible support now? Absolutely. Only the Ukrainians are allowed to commit war crimes. He knew this. Okay, but let's actually have a look at what the defamatory statements were. No, I don't care if it's the end of financial year statement. He says that it's ruined his reputation, destroyed his career prospects. Essentially, he claimed that the reports suggest he broke the moral and legal rules of military engagement and is therefore a criminal. And he has just been found against. So by his own words, he's saying that there is sufficient evidence that a court found that he broke the rules of engagement and is a criminal. Sorry, but if the government's on the side of the media, I automatically distrust the counterclaim. Oz, USA, UK, the government will always act in its self-interest and its own interests. Not disagreeing with you on that, but the government actually wasn't there as a party so much as a third-party joinder because they had to hand over so much information. They were there basically trying to keep the evidence out of court. So... he claimed that and that he disgraced his country and the Australian Army by his conduct. He either denied the allegations of war crimes or said that they occurred in line with the rules of engagement in battle, suggesting that soldiers and former soldiers called to testify against him were simply jealous or too traumatized by the events to remember carefully. So claim 1, unlawful killing. Fairfax articles allege that Robert Smith kicked an unarmed, handcuffed Afghan man, Ali Jan, off of a cliff in 2012. Where his landing was so rough that it knocked his teeth out of his mouth. He then allegedly directed a soldier under his command to shoot him. Robert Smith told the court that there was no cliff, no kick, and the shots were lawful under the rules of war. Fairfax called a number of Afghan witnesses who were arrested in Dewan, which, by the way, is the town in Afghanistan. That's not Darwin here in Australia. It's spelled differently. They arrested in Dewan, and a junior member of Robert Smith's patrol to testify that the articles were true. Robert Smith himself and the soldier allegedly shot Ali Janet testified it was not. This was one of the ones where it was provided that there was sufficient defense and that the allegations were proven to be substantially true. Who'd he piss off? Or was there a breakdown of the checks and balances? He pissed off the media because he came out and didn't really like some of the things that were being said. Of course he deserves a fair trial. Feel like American soldiers like this did shit like this all the time in Afghanistan. Look, that may well be the case, but I think that the problem is that it was so... Can I just confirm? Can you guys, are you guys able to hear the calls and stuff going on around me? Like from the next officer's over or whatever? In which case I should probably go home. But it's like, well, what was I trying to say? Shit. Because this guy was at such the forefront of the Australian military. He was the face of it as one of our most decorated soldiers. Court should have punted this one to a military tribunal. You can't hear the background noise? Excellent. Thank you. Glad to hear that. Okay. So the unlawful killings 2 and 3. The claim by the newspapers was that allegedly Robert Smith pressured a newly deployed and inexperienced SAS soldier to murder an unarmed and elderly Afghan man in a tunnel to blood the rookie. They also reportedly murdered a man with a prosthetic leg with a machine gun in the same tunnel, though he had surrendered. He was then allegedly so callous and inhumane that he kept the leg to use as a novelty drinking vessel. He's accused of killing a civilian, isn't he? That's too far if it's true. Yeah. Yeah, this was an Aussie verdict. It's a disappointing one because there was never going to be any real winners here. Either the claims of defamation were going to be proven to be substantially true, and I was going to be gutted about Robert Smith. But if the testing to the defamation proceedings had gone against the media, it would have been open slather, and that, of all things, was going to be interesting as well. It would have potentially opened me up to defamation proceedings because I've said shit about people all the time. It's a media and now he's lost the defamation case. I think Ben Chu and Camille would have done an amazing job defending him. Look, possibly. Quite possibly. But he did have the best that money could buy as well. The thing that concerned me was that the court thinks that enough of this was substantially proven that he's considering making a costs order on an indemnity basis. Now, you guys might not know the difference about that, so I'm going to explain that very briefly. Ordinarily, here in Victoria and Australia, when you go to court, you win costs for the other party for you having to go to court on one of two bases. Party or indemnity. Party basically means you get some of your costs back. It's, you don't get everything. Indemnity, the opposing party sets the figure and you pay it. Well, he did have bank for it, Luke. That's just it. He had money from his employer who basically backed him. Potty. Party. Difference between an army and a armed rabble is rules of engagement. They're there for a reason. Yeah. How are you able to fight an enemy and win when you have to follow the rules of war and they don't? That's why almost every war of the West has been since WW2 has ended in a loss or strategic withdrawal. He kept the leg as a drinking vessel. Is there proof? Apparently there's enough that it was proven to be substantially true, or the imputations made by the newspapers was substantially true. Picture the leg being used as a drinking vessel. Yeah. Evidence. Robert Smith told the court that there was no one in the tunnel and that the men were insurgents killed in a battle outside the compound. He also said that the leg was souvenired by another soldier to drink beer from. Both sides called members of the Robert Smith Patrol to give evidence, but they contradicted each other. Some of the men said that the man with the prosthetic leg was unarmed, and it was, in one word, an exhibition execution. Others said the killings were legitimate, as the deceased were Taliban members trying to escape the compound. Yeah, there were pics. Number 4, the newspapers alleged that Robert Smith shot an Afghan prisoner between the ages of 15 and 18 in the head with a handgun, boasted to a colleague that it was the most beautiful thing he'd ever seen. Robert Smith said that this never happened. One former soldier testified that Robert Smith had told him it had, while another said the prisoner had been released unharmed. I'm pretty sure that's one of the ones that was decided that was unfounded. They want to talk war crimes and the US government's guilty of that. Oh my god, he took pics of the beer leg. Bad idea. Never take photo evidence. Nope. Unarmed. He was unlegged too. Jeff. Unlawful killing number 5. Fairfax alleged that Robert Smith ordered an Afghan soldier under his command to shoot another prisoner in 2012, or directed one of his subordinates to. A member of the Afghan partner force then allegedly shot the prisoner 4 to 6 times. Robert Smith said that the events did not occur and that he had no authority over the partner force. He also called several soldiers who said the Afghan trooper was not even in prison that day, as he had been stood down for shooting a dog. One later suggested that Robert Smith's lawyers had suggested the events to him. Fairfax had eyewitnesses supporting an account, and another testifying that the Afghan soldier was not removed from the troop. Hasn't got a leg to stand on. Oh, here come the bad leg jokes. Taliban, remember, they like to strap bombs to children and send them to the enemy camps as innocent babes. Oh, hang on. Oh no, never mind. I left the So that's that video that we all watched was from my computer at home because I had it all set up, and apparently it's just moved on to something else. Dude is really broken. Have no sympathy. There was other soldiers, not infantry people, who testified to make me believe it. Yeah, Rare it's a joy. I don't know. I want to see the closed court judgment. I want to know exactly what it was that caused the judge to find this way. Opposing counsel fees are going to cost an arm and a leg. Well, we're talking tens of millions at least. Gilly just based on his overly masculine size and muscles. Okay. Now, the assaults. Fairfax alleged that he punched an unarmed Afghan man in the face and bashed him in the stomach with his knee, with two patrol commanders ordering him to back off in 2010. It's also claimed that he assaulted another unarmed Afghan man himself in 2012 and authorized the assault of another who was in custody and posed no threat. Robert Smith denied the events took place, while Fairfax called other soldiers who said that they did. News reported that Robert Smith ran a campaign of bullying against a small and quiet soldier, including threatening violence. The alleged bullying victim gave evidence for Fairfax that Robert Smith insulted him, was aggressive to him, and hit or punched him repeatedly, and that he reported the issue to the defense force. 3 other soldiers said that they witnessed the bullying. Robert Smith denied any bullying, but said that he believed the junior soldier was of poor character, a coward, and incompetent, and acted on this. Several other soldiers agreed with the assessment and said that they did not witness any bullying. Claim 2. Fairfax alleged that Robert Smith threatened to report another soldier to the International Criminal Court for firing at civilians unless he provided an account of a friendly fire incident that matched his own. The alleged victim gave evidence supporting the newspaper story, and another soldier also recounted phone conversations with both him and Robert Smith that backed this up. Robert Smith said that none of this happened. See, the problem that I have with this is that so much of it is he said, she said. Is there anything that would give him a leg up if it goes to a war tribunal? Oh, that's painful. And then the domestic violence, which they said that the judge said that there was not substantiated enough to provide a substantial imputation, but there was a contextual truth acceptance to this. So while they haven't actually been said that he committed the violence, there's enough of a contextual truth there that they would have been able to dismiss the case, which is effectively what has happened. He had 3 cases, one against each of the newspapers, and each case has been dismissed. It's basically saying that the allegations that they made against him were legitimate. So all these bullying victims were the witnesses for everything. Same thing happened to Eddie Gallagher in the US. They proved that they were disgruntled because they couldn't cut it. Rule of thumb in war, there are no rules of engagement. Kill the enemy, make it out in one piece. Third world countries are going to do the same. Anyway, also suing for defamation over allegations that he punched a woman following a dinner at Parliament House. Fairfax reported the incident occurred at a Canberra hotel as it said that the pair were having an affair, and it coached her how to tell her husband that the black eye was from a falling down a staircase. Robert Smith said that this defamed him, firstly because it was falsely suggested that he hit women, and secondly because it made him seem a hypocrite who publicly supported Rosie Batty, a domestic violence campaigner, when in private he abused a woman. He testified that she sustained her incidents falling down a staircase at Parliament House because she was drunk, and that he nursed her through the night. He also denied it was an affair, saying that he'd separated from his wife at the time. Another witness said that he saw the fall. Fairfax called the woman as a witness who testified that he'd punched her and that she had given the police photos of her black eye and messages from the former soldier telling her that it was a fall, to say that it was a fall. Robert Smith's ex-wife, Emma Roberts, also told the court that they were together at the time. In the movie, the Afghan man will be played by John So finally, Judge Besanko will have to decide compensation for Ben Robert Smith from the Fairfax if it did in fact defame him. Well, that's not what he had to decide, because he's come to the decision that costs will be owed against Ben Robert Smith. I'm not going to lie, guys, I'm still in a little bit of shell shock, because even with the instances that were proven not to be substantially true, the whiskey had legs. Oh, and the other things, of course, they made an application for the appeal time to be doubled. Ordinarily, you've got 3 weeks. They've given them 6 weeks to formulate an appeal, and yeah, so I'm probably going to leave it there, guys, simply because, frankly, I need to go and get a coffee. But it's a little bit insane to me because the allegations that they made were so far-reaching and so brutal. For that to have been found substantially true, I'm genuinely of the opinion that there's going to be criminal investigation for war crimes. I mean, they were already talking about it, but to have every one of the terms dismissed, it's nuts. So, but anyway, on Monday when the full judgment comes out, I will go through that. I'm seeing some new names, so if you're new to the channel, just know that I do a show pretty much daily where I cover law, news, and laughter from Australia and around the world. Yeah, I guess I will catch you all on the flip side, guys. Stay healthy, wealthy, and wise. Cheers, guys.